Hello. Thank you for the opportunity to speak to you, albeit through a video. And I know this will be subtitled, and so I won't speak particularly slowly because there's quite a lot to get through in the 15 minutes or so that I'm talking to you. The first thing to say is this, that the easiest way to incorporate international crimes into the laws of Iraq, that's federal and Kurdistan, it would be for Iraq to ratify the Rome Statute and become a member of the court, in other words, a member of the Assembly of State Parties. Because that brings an obligation to incorporate into domestic law the international crimes which are set out in the Rome Statute. Those being genocide, crimes against humanity, war crimes, and the crime of aggression. Now, genocide is a crime against humanity, but it has a stand-alone status because of the need to prove a specific intent. I'm not going to deal with genocide at the moment, because that's a topic all on its own. But if you want to find out what it means, then of course there's a convention on genocide, but just look at Article 6 of the Rome Statute. Article 6 deals with genocide. Article 7 deals with crimes against humanity. Article 8 deals with war crimes, and then we go on to the newest crime before the International Criminal Court, which is under Article 8 bis. That's the second part of Article 8, which is the crime of aggression. I'm actually going to start with the crime of aggression because that is an overarching crime under which a lot of the more specific crimes come to be committed. And for the purposes of the Rome Statute, the crime of aggression means the planning, preparation, initiation, or execution by a person in a position effectively to exercise control over or to direct the political or military actions of a state, of an act of aggression which, by its character, gravity, and scale, constitutes a manifest violation of the Charter of the United Nations. And it just so happens that we're on the 75th anniversary of the Charter of the United Nations. Now, you'll be more subject to international law already than you might think, because Iraq is a signatory to the Geneva Conventions and Protocols, which covers a swathe of crimes, international humanitarian law, crimes against individuals created during a conflict. But you are also signatories to the International Covenant on Civil and Political Rights, the Convention Against Genocide, 1948, and the International Covenant on Civil and Political Rights. So there is already a plethora of material to which the legal system in Iraq is bound or attached because of the duties required under the membership of those treaties in order to give effect to them in domestic law. The crime of aggression is really a crime which is aimed at the very top of a political or military structure. For instance, the president, the prime minister, the minister of defense, the military man in charge of the armed forces under the commander-in-chief, which is normally the president. And if you look at the crime of aggression contained in Article 8 bis of the Rome Statute, you will see what it says. But what you need to do is to look at the elements of crimes to see where it would be wise to put specific laws into the laws of Kurdistan, which is a sophisticated criminal code already. And I'm not going to deal with all of them, partly because there are so many and partly because I don't have time. But I want to direct you to the ones that you're more likely to come across. Let's have a think about Article 7, Crimes Against Humanity. And the crime that's probably most prevalent in a situation where you're dealing with ISIS, for instance, would be the crime against humanity of murder. And what are the elements that you have to incorporate into domestic law to be able to prove that crime? Well, firstly, that the perpetrator killed one or more persons. Secondly, for it to be a crime against humanity, the conduct was committed as part of a widespread or systematic attack directed against a civilian population. So it's not something that happens on the battlefield, it's against the civilian population. The perpetrator knew that the conduct was part of, or intended to be part of, a widespread and systematic attack against a civilian population. Now, if you can prove those elements of crimes, then you can probably prove the offence against any nominated individual. And for that, of course, you look at the evidence. What is something else that you're likely to find in the situation that was in Iraq and maybe in Iraq again? Well, that's the crime against humanity of torture. Now, as I said, Iraq is already a signatory to the Convention Against Torture. But if you want to incorporate it more exactly into domestic law, then these are the elements you would have to consider. The perpetrator inflicted severe physical or mental pain or suffering upon one or more persons. Such person or persons were in the custody or under the control of the perpetrator. Such pain or suffering did not arise only from and was not inherent in or incidental to lawful sanctions. In other words, there was a lawful sanction that applied to that individual. But again, that conduct was committed as part of a widespread or systematic attack directed against a civilian population. That last one, same as the one in murder, that's a requirement in all of crimes against humanity. And the perpetrator knew that the conduct was part of, or intended the conduct to be part of, a widespread or systematic attack directed against a civilian population. The next that you're more likely to come across is the crime against humanity of rape. What are the elements that needs to be incorporated into the law? Well, that the perpetrator invaded the body of a person by conduct resulting in penetration, however slight, of any part of the body of the victim or of the perpetrator with a sexual organ or of the anal or genital opening of the victim with any object or any other part of the body. Secondly, that the invasion was committed by force or by the threat of force or coercion, such as that caused by fear of violence, duress, detention, psychological oppression or abuse of power against such person, or by taking advantage of a coercive environment, and that the person who suffered was incapable of giving a genuine consent. Again, committed as part of a widespread or systematic attack with the perpetrator knowing that the conduct was part of or intended the conduct to be part of a widespread or systematic attack. Now, there are many other crimes against humanity, and you can see for yourself what they are by looking at the Rome Statute, particularly Article 7.1 G6, which is a crime against humanity of sexual violence. That's wider than rape. The crime against humanity of persecution under Article 7.1H and the crime against humanity of enforced disappearance of persons under Article 711. And you need to look at the articles in the statute, and you need to look at the elements of crimes, because you have to look at those all together. Article 8 of the Rome Statute deals with war crimes. The ones you're likely to come across are willful killing, again, effectively the same as murder. The perpetrator killed one or more persons. But in this case, such person or persons were protected under one or more of the Geneva Conventions of 1949, that the perpetrator was aware of the factual circumstances that established that protected status, that the conduct took place in the context of and was associated with an international armed conflict, and that the perpetrator was aware of factual circumstances that established the existence of an armed conflict. Again, torture arises under Article 8.2a. The war crime of torture is that the perpetrator inflicted severe physical or mental pain or suffering upon one or more persons. The perpetrator inflicted the pain or suffering for such purposes as obtaining information or a confession, punishment, intimidation, or coercion of coercion for any reason based upon discrimination of any kind. Again, the person or persons have to be protected under one or more of the Geneva Conventions. The perpetrator needs to be aware of the factual circumstances that establish that protected status. The conduct took place in the context of and was associated with an international armed conflict, and the perpetrator was aware of factual circumstances that established the existence of an armed conflict. And you'd also want to look at the war crimes of inhumane treatment, the war crime of willfully causing great suffering, the war crime of the destruction and appropriation of property, the war crime of compelling service in hostile forces, in other words, forcing people, where ISIS forced people to fight with them, for instance. The war crime of denying a fair trial. Yes, not having a fair trial can be a war crime. The war crime of unlawful confinement. The war crime of taking hostages. And the war crime of attacking civilians. These are all matters which need to be looked at, as well as every other example that you would find in Articles 6, 7 and 8 of the Rome Statute. And of course, the war crime of wounding a person who was hors de combat, who was no longer able to fight, so that would include a soldier. So it wouldn't simply be a civilian. The war crime of attacking protected objects, for instance, objects related to religion, education, science or charitable purposes, historic monuments, hospitals or places where the sick and wounded are collected, which were not in themselves military objects. The war crime of destroying or seizing enemy's property, other than that would be a lawful exercise, for instance, seizing and using weapons from the other side. The war crime of pillage, and the war crime of using, for instance, prohibited weapons such as dum-dum bullets, the war crime of rape, the war crime of sexual slavery. And these are things that you will all have experienced through ISIS. And so the way to get a better grip on that is to look at the Rome Statute, look at Articles 6, 7 and 8, and specifically then go into the elements of crimes in the Rome Statute, which sets out in respect of every war crime, every crime against humanity, genocide and aggression, those elements which need to be proved before you can convict somebody. And before the case obviously even gets started, they have to be incorporated somehow in the law of Iraq. Now, it may be that you're going to find within domestic law, of course, existing offences of rape, torture, murder, and if all else fails, you prosecute people under those domestic laws. Because if a soldier comes into your country, or a civilian comes into your country, who is not an Iraqi citizen, they are bound by Iraqi law. And if they break that law, then of course they're subject to it in the same way that an Iraqi citizen would be. But there's one thing I also want to touch on that I think is really important, and I think we all need as lawyers and judges to understand more about these days. And that's the evidence that we use in any case, and particularly nowadays, what is called digital open source evidence. That is information that is publicly accessible on the internet. It's being increasingly used before domestic and international courts, human rights bodies, and fact-finding bodies. And it's proved to be very valuable in a variety of contexts. For instance, open source information has been submitted as evidence in a number of cases before the International Criminal Court, and videos found online have played a significant role, for instance, in the case against members of ISIS, in Ukraine against some of the Russian soldiers who have actually videoed themselves committing war crimes. And it's been used in the European Court of Human Rights and in the International Court of Justice. So photos and videos from social media have become instrumental to the findings of United Nations mandated investigative missions, and I think now of UNITAD in Iraq, and the domestic prosecution of international crimes. Because it's a relatively new form of evidence, open source information may be unfamiliar to many legal professionals. So one has to look at it anew and see what techniques there are in order to assist judges and fact finders in their own evaluation of digital open source information. And probably the easiest way to do that to start with is look at the Berkeley Protocol on Digital Open Source Investigations. The Berkeley Protocol was developed by the Human Rights Center in the University of California, Berkeley, and the United Nations Office of the High Commissioner for Human Rights after consultation with international experts. And you will find the answers to most of the questions that you might want to ask about digital open source evidence in that Berkeley Protocol. There is another protocol that is worth looking at. This was one that I personally was involved in, and that's the Bournemouth Protocol upon mass grave investigations and the preservation of mass grave evidence. And where those protocols do not already exist in the law of Iraq, again, that's something that I think is a very valuable exercise, to look at those protocols and to see how they are or how they might be incorporated into the domestic law of Iraq. Now, this is a very, very short overview. I hope it helps. And I hope when I'm next in Kurdistan, which I think will be in January of 2024, I might be in a better position to offer one-to-one assistance or advice, if that's going to be of any great use. In the meantime, I wish you very well in your meetings. Good luck, and let's hope for a more peaceful and prosperous 2024.